And welcome back, everyone, to the National Veterans Small Business Coalition's Charlie Mike Training Series. I'm Zach Armstrong, the Deputy Executive Director with the NVSBC, and I'll be your host today. Before I introduce our speaker, I'll share a few announcements with you. It's our distinct privilege to work and collaborate with these three sponsors to provide you trainings from policy experts, government reps, GovCon educators that bring you information and best practices to grow and sustain your GovCon business. So thank you to BAE Systems, Philips North America, and Bank of America for your support of veteran-owned small businesses that support the federal government. Our Charlie Mike training series is part of a suite of programs that are powered by the Community Navigator Pilot Program through the Small Business Administration. So many of you may not know this, but NVSBC is part of a spoke and hub system as part of the CNPP, and we encourage you to reach out. All kinds of great resources to support the GovCons as part of our coalition. As I shared last time, it's that time of year again, our Vets 23 conference. It's in beautiful Orlando, Florida, May 22nd through 25th. We're lucky this year to work in partnership with the Department of Veterans Affairs. So we know that, we're going to hit numbers, participants, presenters, sponsors, vendors. Our exhibit hall is open more and more breakout sessions. We're really excited, but registration is open. We encourage you to come down and be part of that great event. Again, May 22nd through 25th. You can find that on nvsbc.org at our events. A couple more announcements. One of our best activities and networking events and trainings we have is our Vet Fed Academy and our DC networking dinner. These are in-person trainings. Meet hundreds of other GovCons, federal agencies, service providers, and more. What a lot of us call like the government ecosystem. Come shake hands, make connections, learn, grow your business, find your next teaming partner. There's a lot of activity at these events, and we highly encourage you to attend. And then why we're here today, our Charlie Mike training series. So if you're watching this on YouTube, please do subscribe to our channel, like, view, be part of this interaction process so we can reach more GovCons who want to know about the topics that we're going to talk about today: business planning, business operations, business leadership, federal agency opportunities, and prime contractor opportunities. So we're grateful you're here and you found us through YouTube. And for those that registered, we highly encourage you to register ahead of time. Ask your questions to help make this a rich environment for dialogue. And then our speakers, like today, Paul got a chance to receive feedback from you to help tailor his conversation. So thank you, subscribe, like, and view. And again, with that, it's my privilege to be your moderator today. I'm sharing moderator duties with our program director, Earl Morgan, who many of you know is retiring at the end of May. So if I could ask one plug to do me a favor, if you know Earl, who's been part of this GovCon ecosystems for many, many years, come down to Orlando, say hello, shake his hand, give him a hug, give him a phone call. He would love that. Tell him how much he's meant to you and how he supported your business, because I know Earl's touched a lot of people in a very meaningful way to help them with their business. So, again, just whether it's at a DC dinner or Vets Orlando or phone call, that'd mean a lot. And with that, I get a chance to introduce our friend, Paul Hawkins. So, with being a government contract attorney at the newly named Reaves GovCon group, Paul means a lot to the NVSBC. We know he's been a supporter and a contributor to this space. In fact, Paul and I are part of a working group to bring another networking and training activity in the Norfolk area in Virginia on the 22nd of this month of February. So if you're interested, go to our events, come meet myself, come meet Paul, ask us questions, engage. I know it would mean the world to us. And come have some good barbecue with us at the same time. I know Paul and I are looking forward to that as well. So with that, I'll turn this over to you, Paul. Welcome. And I know everyone's interested to hear more about, succession and leadership changes and all of what you have to say. So show is yours.
All right. Thanks, Zach. Just change over here. All right. I think we're good to go, right?
Yeah, looks good. All
All
yours.
right, perfect. Yeah, and before I even get into it, I was going to say Zach mentioned that we're working on this event here in Norfolk on February 22nd, and I'll just also say full disclosure in addition to being involved with the national NVSBC organization, I'm on the board of the Mid-Atlantic chapter of the NVSBC, and it's been an organization that we've been trying to get off the ground, and ran into some COVID challenges like a lot of folks did, but we're really excited about some of the opportunities there. And so if you're a VOSB, SDVOSB kind of in the Mid-Atlantic area and in North Carolina, Virginia, the Tidewater, Virginia area, especially, love to engage with you on that and get you involved and connect you with the folks here in this local chapter. So, but with that said, let's jump into why you all are tuning in today. As Zach mentioned, I'm a government contracts attorney, and today we're going to be talking about the subject of succession and ownership changes. So, and I titled it, special considerations for veteran-owned small businesses and service-disabled veteran-owned small businesses in the merger and acquisition process. So, just as a starting point, what we're talking about is an overview of this process. And it can be, you may be a business owner out there and you may be considering just an ownership change. Maybe you're considering acquiring another business, another GovCon. Maybe you're considering bringing on a minority investor partner, or maybe you're staging up for the big exit plan. You're hitting those retirement years. You've built your business. You're successful, but now you're ready to transition out to finally get that beach house, get that boat you've been eyeing for a long time, and really just enjoy the fruits of your labor. And now you're facing this last sort of big step, which is to find the right successor to your business. So generally we're going to kind of cover, but in all of that, no matter what of those scenarios I just described, we have to talk through what is this process then for all the different aspects of some of the unique challenges that can arise within the government contracts merger and acquisition space. So that's what we're going to be kind of talking about today. And as Zach mentioned, thank you for sharing some information with us ahead of time. One of the things I found interesting was one of the questions was, have you ever been involved in, or do you have familiarity with the government contracts merger and acquisition process? And we got 100% across the board no. I've not been involved in it before. So that was great background information. Thank you for sharing that because I found those answers interesting, because sometimes folks that maybe are business owners, maybe they were a contracts manager, a larger business or something in the past, or maybe earlier in their career, they saw a slice of the M&A process, maybe in the diligence phase or something, and they have an idea. But we do come across that a lot of times business owners who have, decades of experience maybe in their subject area have never actually really gone through this process. So they're kind of entering it, needing a lot of advice and a lot of guidance. And so hopefully today we'll give you some tools to kind of start thinking about some of the big things in this area, and you take away a lot of info from it. Always have to give this just a quick disclaimer here. Nothing we're presenting today is should be construed as specific legal advice or anything like that. It's more for general information purposes. My colleague Brad Reaves, who many of you probably already know, he also presents a lot for NVSBC. We always say this, that as a government contractor, we'd love for you to reach out to us, let us help you, but there's many really good government contracts attorneys out there, and you really do need legal services that are focused in and are specialized to this area, because there's a lot of unique issues that can arise. All right, so just to kind of give an overview of what we're going to be talking about today, we're going to first start out with just kind of a general warm-up about ownership changes. We're going to talk a little bit about the unique mentor-protege program ownership investment aspects. So that's something that we do some training where we have a more general focused training on the mentor-protege program and on joint venturing and things like that. But we're going to just spend a little bit of time today talking about that ownership share that a mentor can purchase into their small business or SDVOSB, in our case, protege, under the mentor protege program? And what are some of the concerns? What are some of the things to think about through that? Because again, we're kind of couched in this general topic of, of ownership changes and of transfers. Then we're going to talk a little bit about, what are some current trends in the small business, government contracts, M&A space? What are some things we're seeing out there? What are some considerations that businesses need to be thinking about? And, are trends positive? Are they negative? Or are things kind of uncertain, and how that may affect your business? And then lastly, we're going to spend the real meat of the presentation going through both kind of the unique challenges and things that arise with government contracts, M&A, but also the process. What are some of the big areas where, before you get into this process, you need to know, okay, I need to anticipate, this occurring, or this maybe being an issue, or what have you. So we're going to talk through the SBA's affiliation rules and how they factor in to M&A. We're going to talk about some of the very specific SDVOSB succession planning rules that are unique to that program versus other programs. We're going to talk a little bit about business valuations and even all the way at the early stage of the broker agreement and the NDA stage. What are some things to think about at that point? Then we're going to walk through in the ideas of how the transaction is structured. What do you need to be looking at with letters of intent and this term, the SBA's present effect rule, another affiliation avenue that all small business government contractors have to think about. We're going to talk about due diligence. Due diligence is kind of that grinding process where you have to really provide a lot of information, look at a lot of different issues that may arise, and then figure out how to resolve them, throughout the transactional process. Talk about a little bit about the transactional documents themselves. We're going to mention the novation process. That's something that is very specific to GovCon M&A. What happens, when is that process applicable? How do you avoid it? Maybe you want to try to avoid that process, but if you can't avoid the process, or if ancillary to the ownership change, you need to look at the novation process. What is it? What entails, and what are some things to anticipate with it? And then lastly, we're going to look at post-closing. So what are some of the considerations there? What are some of the size, status, notifications, recertifications that have to be made? How do you allocate some of the risk post-closing? And what does a seller need to know kind of entering into that phase of the deal? All right. So jumping right into the first topic, as we mentioned, you have to look at this notion of what about partial ownership changes? What about mentor protege ownership transactions? So the first thing is that as an SDVOSB, carrying a certification. So again, we all know that the certification process is shifted over to SBA. But if you have a current certification, or you're soon to have an SBA certification, you have to understand that there are for any ownership changes, you have ongoing obligations to maintain your certification and make notifications to the SBA if you have a change in ownership. And that's to maintain your certification and to maintain your eligibility when you're representing that you still are owned and controlled by one or more service-disabled veterans. As we talk about later, when you're talking about sort of a total ownership change, you're going to sell the company. That's where we're getting more into the weeds of deal structure and of all these M&A considerations. But just understand this, that if you're taking on, say, a new minority partner, or you're in one of these mentor protege arrangements and you decide to sell off up to 40% of the company, as we're going to talk about, just understand that you have to be mindful of the broader SDVOSB ownership and control regulations that will still apply to you, assuming you still want to maintain that SDVOSB certification. One of the specific ways the SBA kind of sanctions this is through the mentor protege program. So with the mentor protege program, as folks may know, folks may not know that are viewing this, The mentor protege program outlines various areas of assistance that can be allowed for in a mentor protege agreement. One of those areas of assistance is financial assistance. And financial assistance may take the form of an investment or an equity investment in up to 40% of the protege. Really powerful tool here, because you can take on an ownership, an equity partner in your business. You can take them on in a minority stake. And it's blessed by the SBA. You're given basically a shield from a finding of affiliation on that issue. So you enter into the mentor protege agreement, you get it approved by SBA, and then you can enter into this ownership transfer, this ownership change, and as a way of raising additional capital, transfer up to 40% of the ownership. But there's certain things that have to be taken into account. Again, the timing of the transaction, you need to wait until after mentor protege agreement approval. You also have to account for potential issues after the MPA ends. Mentor protege agreements, as some may know who are familiar with the program, they only last up to 6 years. And you may have to plan ahead of time. How are you going to exit out that investor at the end of the mentor protege relationship? How do you take into that account up front? Don't want to spend too much time on this. Again, we have specific trainings on the mentor protege program, but wanted to just spend a few minutes talking about that, because for a lot of folks, that is a way in which you can bring on additional owners and do so while not risking affiliation. Okay, so kind of shifting gears a little bit into the main topic for today. So we're going to talk about the kind of the M&A aspect out there. So here again, we're talking about more the scenario where you as an SDVOSB, maybe you're considering acquiring another business. You're trying to grow through acquisition because you're reaching the end of that, the end of your size standard, and you're looking for ways to grow past that. A lot of talk lately about people really recognizing that cliff you can hit when you start to get past your size standard, and now you're not able to continue to compete for that set aside work, and it can really lead to some really negative impacts for businesses. One of the ways businesses will continue to grow is to grow by acquisition. And so, that comes into play here, but also, again, maybe you're staging up for that exit. And that's where we're really shifting into sort of that territory now and for the rest of the presentation. So begs the question, sort of what's sort of going on out there in the current state of the economy, the current activity in the government contracting market? Well, coming off of 2022, previous to that in 2021, I mean, the M&A market was kind of bonkers. It was white hot. So there was, so much activity, not just in the general M&A market, but especially in the government contracts M&A market. 2022 saw kind of a slowing down of that. Some people, thought it was kind of a little bit of a hangover after the 2021 climate was so active. But also some of that was, as we all know, a lot of uncertainty was introduced into the overall economy, whether that was geopolitical issues such as like the invasion of Ukraine. It was overall impacts in the economy of rising interest rates stemming from the inflationary issues. So that has sort of, we kind of entered into a little bit of a different phase there. And, so there's been a lot of uncertainty in the kind of the overall economy. But I would say that it does seem like there is still a good bit of activity in the government contracts M&A space. One of the, it's sort of a general kind of assumption that when parts of the economy are entering more uncertainty, that government contractors can be a safer area of investment. I mean, again, the government is still spending money. The federal government seems to be growing. There isn't really, even with some political changes and now, entering into a phase of divided government. I don't really see, I don't have a crystal ball, but I don't really see the size and scope of the federal government really changing if if seeing a Republican and Democrat administration for the last several years is any indication. And so it may still be GovCon may still be a very attractive area for investment and for M&A. We're still seeing that private equity is still taking an active role, and expect that interest to continue to stay in place. And so we're really seeing a combination of private equity investors, of strategic investors, and so forth. And so all of that to really say that indicators, fundamentals still seem to be somewhat strong from what we're seeing. But we're kind of not in that really strong place we were about 18 months ago or so. And the last thing I'll say there is on that last bullet point, one of the things we've been hearing from some industry experts and so forth is that with small business government contractors especially, it's always been an assumption and a concern that having set aside work in their contract portfolio is something that's going to really drive down valuation. I think that's still a concern and something you have to work through, but it does appear that things like capabilities, differentiators, is your business really, do they really have kind of a certain approach, a certain product that is part of a bigger trend of maybe of a place where in the near and extended future that there's a lot of potential there. Those are the kinds of things that it seems that investors are really looking for, and they kind of trump maybe other concerns. And so that's another thing to think about. How are you maybe setting yourself up, and are you really getting on those certain differentiators that may make you more valuable and drive value up? Are you just speaking to the defense space? We're in Hampton Roads. We have a lot of defense contractors, of course. Something like that. Or are you in those areas where you're showing you're showing that you can support the trends to address, say, like near peer competitors to the Defense Department or something along those lines? So we are seeing some of that discussion as well. All the way up front here, I wanted to also spend one slide talking about some of the very special roles that are really just unique to just the SDVOSB program, and kind of tie in with this area of succession planning and of ownership changes. So the first one is actually the surviving spouse role. So the surviving spouse role is a role that under the service-disabled veteran-owned small business program, it allows a surviving spouse to essentially step into the shoes of the veteran owner if the service-disabled veteran owner is deceased, to step into the shoes of the owner and to maintain the company's SDVOSB eligibility for a certain period of time. So it's a really good way that it allows, if, say, for example, if there's a concern over health or something like that, you can tie that succession planning into with that role. So you at least know that for a certain period of time, the company can maintain SDVOSB eligibility, but with the surviving spouse. And so the only really moving parts of that rule is that if the service-disabled veteran-owned they're having died, if it results in less than 51% of the SDVOSB being owned or controlled by a veteran or veterans, if the spouse succeeds to that ownership, they can maintain that eligibility. And for the period of time is until that surviving spouse either remarries, they relinquish that ownership, or in the case of a veteran with 100% disability rating, it's for a period of 10 years, or if it's less than 100%, for a period of 3 years, sort of notwithstanding those other things. So again, a rule that that sort of goes into this idea of succession planning and of ownership transfer, because let's face it, with a lot of small businesses and closely held businesses, for owners, their own estate planning often ties in with their succession planning. And that kind of thing. And so this is something I think that veteran owners need to be aware of and smart on, that this rule applies to them. The other thing to consider is the unconditional direct ownership requirement. So as probably folks listening in here definitely know, that like with any program where the focus of the socioeconomic program is on the individual owner, so SDVOSB, 8A, women owned, et cetera, the ownership is that it has to be direct and unconditional. So, you can't, as an SDVOSB, you can't own your ownership interest through a holding company, for example. We all know that. So that is something that structurally you have to own it individually. You have to own it directly and unconditionally. So therefore, you can't, for example, get SDVOSB eligibility through an ESOP, right? So I know ESOP is often an attractive way in which one can transition, but just be aware that if an ESOP is the resulting ownership, and the concern is not 51% directly and unconditionally owned by a service-disabled veteran, it's not going to still be SDVOSB eligible. You can own your ownership interest through a trust. That is permitted, as long as you meet certain special requirements. And so again, when you're contemplating, maybe transferring your ownership interest into a trust as part of that estate succession planning, like I just mentioned, you need to be smart on these rules and flag those to make sure that that trust you set up is compliant with the rules. Lastly, I want to mention this. This is a very new development, and it's part of the SDVOSB ownership rules now. So part of the recent rule changes is that under this requirement of unconditional ownership, the SDVOSB rules now actually provide that you can have a contractual right or a contractual right of first refusal for a non-qualifying veteran co-owner. So that's huge, because previously the unconditional ownership requirements were construed very strictly, and a lot of times, just in general, that is a common and almost expected protection for a minority owner, to be able to have that right of first refusal, just to help protect their own investment and their own ownership stake in the company. And so the SDVOSB rules now permit that. They actually permit a contractual right of first refusal for a non-qualifying veteran minority owner, and that doesn't otherwise affect the unconditional nature of the service-disabled veterans ownership, and that would, quote, follow normal commercial practices. Now, I don't know if that's really been fleshed out too much. I've not seen a test case of an operating agreement or a stockholder agreement or something like that going through the new SBA certification office and them sort of giving a thumbs up, thumbs down on that yet, but the rules do permit that. But one thing I will say, with that, is that as of right now, the SDVOSB program is the only program where such a rule has been expressly included. So just keep that in mind. If you were also, say you're an SDVOSB, but you're also in the 8A program, or you're also a woman-owned small business, to our knowledge, there's no other guidance or interpretation, or there's definitely not any express rules that mirror that in those programs. So if you want to maintain your women-owned small business certification, for example, you may not be able to take advantage of that rule. But we just wanted to kind of highlight that new rule here in this slide deck. Okay, so sticking with our favorite, set of regulations in Title 13 of the Code of Federal Regulations, the SBA rules, we need to talk a little bit about affiliation. So from a very general perspective, everyone, kind of needs to take into consideration to remember that when you're determining a business's size, you count the receipts or employees of that concern, of it and all of its, quote, domestic and foreign affiliates, right? So remember, size is never just your business. It's also your business plus any of your affiliates. So again, there's no rule against having affiliates, but just keep in mind, if you have an affiliate, they now count in with you for your size. That's outside of M&A. That's a rule across the board. If you're going to qualify for SDVOSB set aside, sole source, general small business set aside work, you have to remember that your size is calculated with your affiliates. Again, we talked about the mentor protege program. That's an exception to affiliation, where if you do that 40% ownership change under your mentor protege agreement, that's not going to be considered as a basis for affiliation. But the key thing to keep in mind about affiliation, because you could spend an entire presentation just talking about all those rules, is to keep in mind that control is the base concern, is the base issue when you're talking about affiliation. That's what all those avenues of affiliation come back to: is does another entity, do you or another entity have the power to control, or can you exercise the power to control each other, or does a third party have the power to control you and this other party? Then you would be considered an affiliate. Why this matters here is that if through the M&A process, through, say, the present effect rule, which we'll talk about more in depth here in a few slides, if you take on affiliation, it may impact your size representation. It may impact your eligibility for SDVOSB set-asides or other small business set-aside opportunities. On the flip side of it, if you are going through some sort of corporate transaction, you could take advantage of the former affiliate rule. So in other words, you could actually shed, an affiliate for the requisite period for determining size, assuming, you're complying with all the aspects of the rule. And that's why this all kind of comes into play, because keep in mind, the M&A process, just like the procurement process with the government, it doesn't happen overnight. It may last for several months, right? Or you may be under a LOI with a company for a year. I mean, it could happen that way. And so you're presumably still bidding on work during that time. And that's why this affiliation question actually comes up and actually matters, and should be kept in the back of the mind of the business owner. All right, so kind of getting to the meat and potatoes of the M&A process. So the first thing that businesses will obviously think about is the business valuation piece, right? What are we talking about here? And so the takeaway from this slide is that last bullet point. Ultimately, what a buyer is willing to pay is what the valuation is. Where you start from is sort of key to the process. So you may have a CPA valuation, you may have an independent third party value your business. You may have a seller, there's a quality of earnings report. I mean, a Q of E is sort of an independent diligence of your financials that may take into account more than just, say, like your net income, right? That may not be its own by itself a very good indicator of your true business valuation. A quality of earnings report is going to give you a better indication of that. There may be a buy side Q of E, right? That as part of the diligence that will impact the ultimate purchase price. And then, of course, from the buyer's perspective, the due diligence process is an opportunity that can impact purchase price. It may, if it's going to impact it at all, it's going to reduce it, right? Maybe something comes out during that diligence period that has to be accounted for, which, through ongoing negotiations may reduce a purchase price. But just, again, keep in mind that at the end of the day, a valuation is what a buyer is willing to pay, but it really does kind of drive you in certain areas at the beginning of the process, and serves as kind of a starting point for where your business may slot in. Also, at the very beginning of the process is when you're looking at engaging, say, a business broker and other M&A advisors and so forth. And one of the first sort of really important, beyond just maybe like a rudimentary non-disclosure agreement where which you may sign very early in the process, is the broker agreement. The broker agreement, what we've seen oftentimes, it can be overlooked by the business owner seller. They may just sign it and not really give much thought to it. But what we really advise is that take this broker agreement very seriously. It can have all kinds of terms in it that could come back to bite you later in the process. And if you don't really account for it, you may find out too late. So we recommend, I hate to make kind of what sounds like a self-serving recommendation, but we recommend reviewing that broker agreement with M&A counsel before signing it, and really understanding, what that fee structure is for the broker. Is there a tail right at the end of when they could be entitled to fees? What's their retainer? What's the success fee? I mean, all these kinds of things. What's the scope of their representation? Again, we almost never, advise that, there be dual representation, but sometimes we see that kind of stuff come across our desk. And so all these things really need to be taken into account. And again, we recommend, if there's any takeaway from this slide, it's, the foot stomper here is don't just sign that broker agreement. Make sure you're having it reviewed by a trusted legal professional. Okay. So we've talked about valuation. We've talked about, getting the broker in play. Maybe now you're looking at, a few offers. You're gonna be getting into the process. We'll talk about the LOI here pretty soon. But one of the things that you have to keep in mind is the structuring of the transaction. How do you plan for that? And there's all kinds of things that really can come into play with that. One is our tax consequences and structuring. That always comes into play, and we'll mention here in a slide coming up, but you really have to have a team of advisors around you during the deal process, beyond, just an attorney or just a good broker or investment banker or M&A consultant. You really need to have a good CPA, your company CPA or somebody like that. You have to have some good advice in the tax realm to make sure the transaction's being structured properly. You also have to look at things like the legal, what are some potential legal issues that may arise? In the GovCon space specifically, we'll talk about it more in a minute, but the novation process is something that has to be taken into account. So, for example, general kind of commercial world, oftentimes an asset deal is what is more advisable in a certain situation. And in doing so, you sell off the assets of the company, including all the current, customer contracts and everything. You just assign those contracts over. I was going to say easy day, but it's never an easy day. But that's how you do it, right? But when you have government contracts, there's a little thing called the Anti-Assignment Act, and that statute actually prohibits you from assigning government contracts. You instead have to go through the government novation process, and so. But that process is not required in an equity deal. And so a lot of times government contracts, acquisitions are structured as equity deals and not asset deals for that very reason. And those structures are different, and they have different considerations, different issues that arise. And so these are just all things that one has to consider. And then finally, kind of mentioned and alluded to this asset versus equity purchase. A lot of it goes into, how is risk allocated? Like I said, with government contracts acquisitions, 9 times out of 10, you're doing an equity purchase because you're trying to avoid the novation process. When you do an equity purchase, keep in mind the buyer is buying all the assets and the liabilities of the business. They're just taking over the ownership and the entity, at least for that, for the time being. They may have different ideas for it post-closing, but at least for the time being, that entity is staying intact. It may become a wholly owned subsidiary of a purchasing entity. It may be, it may be individuals coming in and buying it, but that entity is not going away. The ownership of it is just changing. And so when that happens, the buyer has to account for the risk in doing that, and they do so through the diligence process, through the purchase agreements, representations, and warranties, where you as the seller owner are representing and warranting that there's certain things about the business that that are intact for the buyer. What we've seen a lot lately is the use of representations and warranties insurance. So that's been around for a long time, but we've seen it kind of proliferate more and more. And that's where there are actually insurance providers that will underwrite that transaction. And so if there's ever a breach of those representations and warranties, there's actually an insurance policy on that, and that can be yet another thing that fits into sort of the complexity of a deal. Yeah, so we kind of already been talking about sort of the initial stages, initial discussions between a prospective buyer and seller. Again, one of the first agreements you're going to see come across is a non-disclosure agreement. And this was separate from the one I mentioned earlier, which may be in place with like a broker. But you may see an NDA, come into play, or you will see an NDA come into play with a prospective buyer, and that would be, one of the first agreements you see, and then of course you have the actual letter of intent that starts to really kick off the merger and acquisition process. Again, I stressed earlier that having M&A counsel review your broker agreement is essential. I'll foot stomp here again. You really need to have specifically government contracts counsel, as well as just general M&A counsel, review a letter of intent. Again, this is, there's even more, potential areas of risk in a letter of intent if you don't negotiate it properly, because the letter of intent can have various things about exclusivity. It can have, items about timelines for diligence, for how the transaction is going to be ultimately structured, purchase price adjustments, things of that nature. And again, if you just kind of just gloss over it and sign it and think it's sort of a formality, you may be inviting some pain onto yourself later in the process. We've seen this. What happens when you want to get out of the deal for some reason? What does your LOI say? But lastly, from a GovCon perspective, the really key issue is this present effect rule. There we go. Sorry. So with the present effect rule is a way that affiliation can be found between a potential buyer and the target company. And what happens is that the SBA has said that agreements to merge, including, quote, agreements in principle, will have a present effect on the power to control a concern. So the SBA treats those agreements to merge as if they've already been exercised. And this would even apply to, say, like convertible equity or something like that. Is kind of couched under this same rule. So an LOI, if it has, if it's structured in a certain way and has certain terms in it, even though, you don't think it's really binding, but it has certain binding terms, the SBA could find that to have present effect and therefore create affiliation. Why is this important? What's the so what here? Well, the so what here is this. If you sign an LOI that doesn't take these things into account, you could be deemed to be affiliated with that buyer at that moment. So let's say you're turning in a proposal a month later for an SDVOSB set aside, and you don't really think that, I don't need to count you would actually need to think about counting that new affiliates, receipts, or employees in with your size standard. And most selling companies don't think about that. And then what happens is somehow a competitor may get wind that you're under an LOI with this potential buyer. They file a size or status protest, and guess what? You're now found to be affiliated with that entity. So how do you avoid that? Well, it's I would say, again, nothing is easy, but there are certain things you can do to specifically to avoid that. One, like I said, have counsel that's familiar with government contracting issues, review that LOI and negotiate it, and make sure that the terms of the LOI are generally non-binding, and that certain terms are not included that the SBA Office of Hearings and Appeals has in the past taken issue with. And some of it is just providing a little magic language in there, calling it instead of a letter of intent, calling it a letter of agreement to open or to continue negotiations, right? Some of it is just kind of characterizing it differently, specifically referencing this SBA affiliation rule to say that the parties do not intend to create those kinds of things would certainly express to a future reviewer that there was never an intent to create control or the power to control in this scenario. So again, LOI, present effect rule, that's the big takeaway here. If you're an SDVOSB and you're selling, you have to be considering that at the LOI stage. All right, I know it's been kind of a fire hose so far, but what are some, kind of shifting, into still in the kind of the M&A process itself. So what are some of the unique aspects of GovCon M&A? Well, one we talked about a little bit is this idea of set aside contracts and how they can create challenges for business valuations. So a lot of times what we see in government contracts M&A is, a seller will have, a company will have a certain portfolio of set aside contracts. And then you have to parse through, okay, how are we going to work through that with a buyer that, may after closing not continue to be eligible on those set aside contracts. And at the very end of the presentation, we'll talk about post-closing notifications, recertification, what those impacts are. But a lot of times the risk involved in whether those contracts will still be eligible has to be allocated in the process. And so what we hear, or what we see, excuse me, is we see a lot of times, the use of escrows, so like some holdbacks. We see some earnout provisions that will take that into account. Kind of already alluded to this novation piece, but again, if you're structuring it as an equity deal, you avoid the novation process altogether. But if there are overriding reasons to structure it as an asset purchase, then you have to then take into account the novation process. I'll also mention here that sometimes ancillary to a sale, maybe a need to, for lack of a better word, peel off a contract. And so you can actually use the novation process there to see if you can sell off, say, a certain business line or a division in a certain subset of contracts to a different entity in order to sort of get them, kind of get them out from under the tent of the business. And sometimes that's actually where the novation process will arise as well, even if it's not sort of a full-on sale of the company's assets. Back to these kind of initial transactional stages, one key piece is the seller getting their due diligence house in order. Sometimes, we come across companies that are trying to sell, and, frankly, we have to kind of just break it to them that they're maybe not ready yet, right? They need to really make sure that they have looked at their own contract portfolio, their own potential employment issues and legal issues that they may have, and have addressed those things. So when they're fully ready to kind of go out to market, and that a buyer is going to actually think that they're an attractive potential investment. And so getting that diligence house in order is a crucial step. And it happens maybe even well before you've entered into this process. But unfortunately, sometimes what we've seen is it happens by necessity, because maybe a seller kind of dips their toe and they realize they're not quite ready yet. They have to then go back and then maybe push off the process for another year or so they can get their house in order. Finally, is assembling that deal team. We talked about that a little bit already, but having the right legal counsel and tax accountants and counsel in place, making sure you have good, reputable, trusted industry consultants, M&A consultants, and brokers in place that can really advise you through the process, because it really is a team effort. I'll stop here to say this, just to give a practical note. As I mentioned earlier, it seems that a lot of the folks listening in may not be familiar with the process. And, I'll just tell you up front, the process can be pretty cumbersome. Obviously the reward at the end is great, but the process can be cumbersome, and you have to be prepared to spend some money. You have to be prepared to have in place a good, strong team of advisors. And, there's going to be cost with that, but it ultimately works out in the long run, because you're able to work through and identify and work through issues that you wouldn't otherwise be able to do so. So you have to just be prepared to bring on that strong team of advisors. A lot of times in these initial stages, there has to be, arrangements for financing on the buyer's side. And then, once the LOI is signed, you enter into the due diligence process. So what is the due diligence process? So that process is just when, the buyer is, think of it, the buyer's kind of kicking the tires. They're kind of, peeking under the hood to see if what they are going to spend their money on is really, really worth it. Like we said earlier, sometimes in this diligence process that's when, purchase price adjustments may come into play, or when the terms may start to get negotiated, maybe with a holdback or an earnout or something, because of things that are uncovered in diligence. We could spend several minutes talking about all the aspects of diligence, but I'll say here, beyond just the normal things that a buyer is going to want to look at, from just basic legal due diligence and looking at financials, looking at any kind of current or threatened litigation, looking at ownership of intellectual property and employment issues, things of that nature. Those are sort of what buyers look at more generally. In the realm of government contracting, you can arise to very specific GovCon issues. So, do you have any pending REAs or disputes with the government? Do you have anybody that's ever faced suspension, debarment? Have you, do you have any potential False Claims Act suits out there against you? Or is there pending litigation in that realm? Do you have all the right ethics and compliance programs in place? Are you ITAR registered, right? There's actually notifications and processes to go through if you have an ownership change with the State Department. If you're ITAR registered, do you export? And if you do, are you compliant in those regards? How's your cyber hygiene going? Have you had a cyber incident and a breach? Are you under the DFARS cyber clause? And if so, have you implemented that properly? Are there any security clearance issues? There's also post-closing notifications involved with ownership changes if you have a facility security clearance. We've had to deal with this before, kind of uniquely. We don't deal with a lot, but we've actually helped the seller through this process. He had a foreign buyer and had a facility security clearance, and so if you're going to have foreign ownership, control, and influence, you have to work through several approvals and issues there that you wouldn't otherwise have to do. But if you have sensitive government contracts and you have a facility security clearance, you'll have to work through those things if your buyer is a foreign buyer. So again, lots of due diligence concerns happen there. Typically in the process, what happens is a data room is set up where the buyer requests answers to multiple questions, requests lots and lots of documents. And the lawyers are really kind of doing a lot of the grunt work there. Your consultants, your M&A advisors, and your brokers may be helping to facilitate that, but your lawyers are really doing a lot of the grunt work and organizing that data room, really going through it, and then answering the buyer's questions on the review of all that. Okay, so you go through that, what can often seem to be a lengthy and painful diligence process, but you finally get to the transaction closing. Just to note, there are several moving parts in that process that you'll be looking at, any kind of restructuring or entity changes that have to happen, any filings that may go with that. You may have a lot of ancillary agreements that have to get executed, like employment or consulting agreements. Again, if you have to go through the novation process, that's something that's going to be being prepared and to be submitted to the government. You may have to assign several subcontracts or vendor agreements, or you may have already had to review any change of control provisions. You have to go through the process of transferring assets and employees and other material contracts over to a buyer. If there's any lump sum payments involved, you have to there's going to be exchanging of funds. That's the exciting part, right? But there could also be promissory notes involved. Again, the big takeaway here is a lot of moving parts, but that's why you have your strong team of advisors in place that help facilitate that piece. We won't spend too much time here, but just understand that there could be a wide difference in the different types of payment structures. So from buyer and seller side considerations for payment, for the payment structure, there could be a payment in full at closing, right? That's what you as the seller want to see. That would be nice, but there also could be an exchange of promissory notes and things like that. But we've kind of already alluded to that. Maybe there's a combination of different types of payment. Again, with the novation process, just to kind of familiarize everybody with that, we're kind of getting to the end here, but if you do have to go through the novation process, again, the reason for that is the government prohibits the assignment of your government contracts, but if you are going to transfer them to a new entity, the FAR provides that you can submit a novation request to the appropriate contracting officer. The novation package includes, several required documents. that the FAR outlines for everything from copies of the underlying transactional documents to buyer and seller financials, to the buyer's capability statement, past performance data, all kinds of things like that. It's submitted up to the appropriate contracting officer. But the thing about the novation process is, and this is why people try to avoid it, is that at that point you're completely at the whim and at the government's their discretion, really, in how they and whether or not they'll approve it. The government can approve it or not approve it, and they don't really have to give you a very good reason. And also, they're not under a certain timeline. And so you may be, kind of hot and fired to get your novation package approved and your novation request, but oftentimes you may be at the bottom of their list of the things that they are doing. And so the novation process can be fairly arduous. And so what we see often is that deals are structured as equity deals so as to avoid the process. Or if it does have to be gone through, it can, I don't want to be too, down on the process. Most of the time we ultimately see the government approve the novation, but it's something that you have to, you can't really guarantee is going to get approved and within a certain period of time. And then sort of the last couple of slides here we'll talk about is with, post-closing considerations. So, there's a lot of moving parts. So some of the integration issues that happen, we talked about earnouts and holdbacks and things like that. One of the situations you hopefully you don't find yourself in is if there is, what is discovered to be a breach of representation, your representations and warranties in the agreement and any indemnification rights that may arise because of that. Whereas the seller, you have to indemnify the buyer in some way under the agreement. That's something that could arise after the closing. But again, one thing that we could have talked about, we didn't really touch on earlier, but one of the negotiation points often in a purchase agreement is this, the caps and baskets there, what is considered material and things like that. But that is something that could come up in post-closing. And then, the last thing we'll touch on here is for SDVOSBs and other small business government contractors specifically, the question often arises is, okay, so if I get purchased, if my business is now owned by, say, a large business or by private equity, and now I'm affiliated with several other businesses out there, I'm now clearly not eligible anymore for SDVOSB set-aside work. How is that, what happens and how is that going to impact the contracts? So, again, before we even get into that, it goes without saying that we oftentimes see, strategic buyers, say a service-disabled veteran individual with a group of partners will want to come in and purchase a business with the very intent that they'll maintain the SDVOSB eligibility or become SDVOSB eligible after closing. But oftentimes what happens is after closing, that concern is not going to be a small business anymore and is not going to meet the SDVOSB eligibility requirements. So what does that mean? What happens? Well, first of all, a notification has to be made to the contracting officer, and the reps and certs and SAM have to be updated within 30 days of the closing or the approval of the novation if that's the case. And oftentimes sometimes we put there the multi-million-dollar question is okay, well, what's the impact going to be there? Are you going to lose those contracts? Are they going to be terminated? Are you not going to be eligible for any more options? Are you not going to be eligible for any task orders into those contracts? Well, the SBA has actually, I think it used to be a lot more uncertainty around that question, but it seems that the SBA's interpretations and there's a lot more comfort here that what the clear impact is that the agency, if you are no longer small or SDVOSB, that the agency cannot take further credit under that contract for the award dollars. Right? That's the clear impact. And so that's kind of transparent to you, the business. You don't really care about that. What you care about is continued eligibility. So what happens is that the rules are a little more clear now that that the agency can continue to exercise option periods. Again, keeping in mind that exercising options is always at the government's discretion, but they can continue to exercise options on that contract, and they can continue to award task orders on that contract. They just can't take credit anymore for it being a small or SDVOSB spend. Now, there has been some updates to the rules with multiple award contracts. For example, if you are under a multiple award contract, let's say it's an unrestricted MAC, right? But then a task order is set aside for SDVOSBs or small businesses. If the contracting officer is asking you to certify your size for that task order, post closing, you obviously can't do that, even if you got on the MAC before the sale. Right. So it's sort of all about the point in time that you're having to represent your eligibility. But again, for those existing contracts, they should stay in place post closing, but there is a notification that has to be made. There's some specific rules for joint ventures. If you're part of a joint venture, for how those notifications have to be made. Again, all these things that have to be taken into account. And by the way, again, come up in that diligence process, come up in the structuring of the purchase price, and it shouldn't be a surprise after closing. And again, it goes without saying, but you have a change in ownership, like we mentioned all the way back at the beginning of the presentation. There has to be an update to the SBA about whether or not that concern is still an eligible SDVOSB. And if they're not, you obviously lose that eligibility, but you have to assume that the buyer has already planned for that and they're taking the business kind of in different directions. Okay, so I know that was a ton of information that I just kind of put out there, going all through the process. But kind of we reached the end here. I got a question slide here. I know there's a couple of questions that Zach already had, and happy to kind of answer those now.
Yeah, I appreciate that. So thank you, Paul, for we'll get into some of the questions right now. Two that came across very specifically. One asked, where can I find a list of VOSB and SDVOSB businesses, potentially by geographic area, NAICS code, revenue size, or any other forward things that you discussed today?
Right. Yeah, no, so I think answer to that question is someone like myself as a government contracts attorney, I don't have sort of a special list of different SDVOSBs and things of that nature. But where I think that question is getting at is sort of maybe getting some intel, right, on where there could be potential acquirers or other potential partners and things of that nature. There's all kinds of public sources where you can look at who the current certified SDVOSBs are. If you want more specific information, I think about specific entities that you could maybe they're a target entity that you're looking to acquire another business or something. Some of that information I think is going to come from those reputable, trusted M&A advisors who know who can potentially put together these kinds of deals. But I was going to kick it back to Zach and say that the NVSBC is actually a really great resource for something like that.
Yeah, appreciate that, Paul. And at the same time, I can echo your sentiments in terms of the right advisors. That's their job. They have that ecosystem. They're aware. But in terms of NVSBC, part of our value for the member organizations, the folks that become members with us, our VetFed Connect. If you go to the top of our website and click on the red button in the upper left-hand corner, that gets you access. Even prospects have access to some limited information, but that's NAICS codes, all different types of information that's publicly available. But it's 48,000 organizations that are VOSB, SDVOSB, and kind of that ecosystem. It's all publicly available information. But on top of what our members and prospects provide that they want out there, so folks can search for them. But then that's also part of the membership value on our side. We work with our member organizations to find information or even request it in certain spots. So, okay, transitioning to the second question, in terms of, I think you covered some of this, but maybe we could vector in or hone in on They're asking, what are the top priorities in your mind when planning to acquire or exit a VOSB or SDVOSB?
Yeah, I mean, there's a lot of ways I think to answer that question. Obviously we just went through, again, like I said, I feel like I'm opening up the fire hose for a lot of people, in this just hour of material here with so many different aspects of the process. Some of the things just that we see that I would say is one is start planning early for that exit. Start planning well ahead of time and start really strategically thinking about how you want to position the business, and what kind of way, how do you want your contracting portfolio to look when you're ready to sell, and that would be a place to maximize value. Mentioned, getting your due diligence house in order. Are you for example, are you a DoD contractor? Are you set up for CMMC? Are you set up for having the right, to having all the cybersecurity, issues in place, or are you handling any potential issues out there, and are you examining what you're doing and your business practices to make yourself most attractive to a buyer? I mean, I think those kinds of things are huge. The other thing is that, again, especially for folks that are not familiar with the process, I think you just need to, you really need to kind of prepare yourself for what can be a pretty lengthy and like I said, can be very expensive process. Sometimes I feel like this is a classic lawyer M&A presentation here. I'm talking all about process and all about the problems that could arise, and all of that. But I think it's very important to understand up front that, you really do need to have that, and I've said this probably a half a dozen times, but really have that team of advisors that's going to walk you through the process. It's money well spent, but you just have to be, I think, you have to be just prepared up front that you got to have that in place, and it can be lengthy, but the reward at the end is obviously well worth it. Again, like I opened up the presentation with, if we're talking exit, remember at the end is you sitting at your nice beach house after you just sold the company for $10 million. So that reward is waiting for you at the end, but just remember, it may take a little bit of time to get there.
Until they get sick of the beach or the beach house and they start another company.
Well, and then you're on the other side of the process.
Yeah.
So that's right.
To kind of piggyback off what you said, like we certainly see organizations that come to the NVSBC and ask about this as part of the reason why we have such a training and get Paul and other experts involved. My takeaway from you is, get started, start talking about this, like have an end plan in mind, and it can always change, but like you got to start taking some reps and getting this language so you can understand what it's going to be like.
Exactly. Yep.
Oh, okay. Well, honestly, on behalf of the board of directors, our staff, Paul, all of our members of the coalition, we appreciate you making time out of your schedule to share your knowledge to GovCons who are going to be in this spot one way or the other. They're going to be surrounded by it again in one way or the other. But thank you. And I do want to thank our sponsors again, Bank of America, BAE Systems, and Philips North America. To everyone watching, clearly you can see Paul's contact information there. Please reach out to him with any questions. You may contact me at any time at zach.armstrong@nvsbc.org. Again, we have several trainings and events that marry up with our Charlie Mike training series, and we wish you all the best, and we're here to support your efforts. So until next time, take care, everyone.
Thanks.